This week, the OCC made a major announcement about the ability of U.S. banks to provide cryptocurrency services. The OCC is the primary federal regulator for federally chartered banks and thrifts in the United States. And it made the announcement that those financial institutions are now allowed to provide custody services for crypto assets. And that has the potential to radically shift how cryptocurrency is handled in the United States. So today I'm going to talk about the OCC's opinion and what it means for banks and FinTech companies who are interested in providing cryptocurrency services in the United States. For those of you who are not familiar with U.S. banking law, the significance of the OCC's letter might not be obvious. And that's because the ability of banks to engage in different business activity in the United States is very carefully circumscribed. So most companies in the United States can do whatever kind of business they want. A lumber company can decide it wants to make a rap album. Or if you are a restaurant chain, you can decide that you're going to start producing computer software. But banks are not like that. Banks are only able to engage in activities that are defined by statute as the business of banking. And it wasn't at all clear that providing any cryptocurrency services, including storing crypto assets on behalf of clients, constituted the business of banking. And now we have a definitive answer to that question. So as opposed to other kinds of activities that banks can't engage in, so a bank can't engage in producing a rap album, even if it wants to. Maybe that explains why we don't see a lot of bank rap albums. Banks can engage in the business of providing custody services for crypto assets. The OCC's new opinion potentially opens up a huge new market for financial institutions in the United States. Previously, banks had been reluctant to engage in any kind of cryptocurrency business. In fact, they haven't even been willing, in many cases, to even open up accounts for companies that are in that business, much less handle the crypto assets themselves. But this new opinion that was put out by the OCC really opens the door to the possibility of banks engaging in lines of business that involve cryptocurrency. And that's tremendously exciting both for banks that are interested in doing this kind of work and for FinTech companies that are interested in partnering with banks to provide various forms of crypto services to people here in the United States. But there's still a number of legal challenges. Now, first of all, it's important for any financial institution to ensure that when it adopts a line of business that is based on crypto assets, it still complies with anti-money laundering regulations. It's also critical to comply with infrastructure requirements. So cybersecurity, defenses against hacking are particularly important when a financial institution is holding a cryptographic asset that, if it gets out of the bank, can lead to an immediate irreversible transfer of, say, Bitcoin or Ether on the blockchain. And so it's incredibly important for financial institutions to ensure that they have those systems in place, both in terms of anti-money laundering and cybersecurity, before they implement any of these new lines of business that are based on cryptocurrency. And then finally, it's just important to engage in the same kind of due diligence that banks are required to engage in for any line of business. So anytime a bank adopts a new product, they have to ensure that it's consistent with the safety and soundness of that institution. So there's still a lot of complexity out there. There's a lot of legal challenges, but good news, I'm a lawyer. So if you have any questions about the possibilities that are really being opened up by the OCC's new opinion letter and how you as a bank or you as a FinTech company can take advantage of this new opinion and take advantage of the ability to hold crypto assets on behalf of clients, give me a call. I'd be happy to talk to you about it.